my first web development. I now exclusively do privacy and data security work because that keeps me busy enough. So I can't keep up with other areas of law. and so that's my focus. And of course, in that context, there are a slew of social media related cases that come up and that affect people and affect organizations. So that's my focus. It's all on the privacy and data security side of things.
All right, so on that note, do you...
Probably need the clicker. Someone
Yeah.
needs the clicker.
I can do it. Yeah.
Okay. All right, that's how it is in my house. Well, I just wanted to do kind of a real quick introduction to tee up the discussion today. The topic is Facebook marketing, legal and regulatory compliance. And we have 45 minutes. So Fazila and I got on the phone and we said, you know, we could probably spend 2 days talking about legal and regulatory compliance for Facebook marketing. What can we do in 45 minutes that's going to have some meaning to our audience? And we were talking about what's kind of going on right now in media, in marketing, in social media, and obviously with Fazila's background, we both seized on the issue of privacy. So today what we're going to do is really just focus on the privacy issue, and at the end we're going to save some time for questions, and I certainly invite you to ask whatever questions you might have about legal and regulatory compliance for Facebook marketing, but we felt we really wouldn't be able to provide any value to you if we tried to do a survey of legal and regulatory compliance on Facebook. It's just too much. And certainly offline or after this, you're welcome to contact either one of us with any questions you might have. So with that said, I'm going to let Fazila kick it off.
Okay, excellent. I can't see everybody. Can everybody see me? Kind of. Yeah, you know what? Is that or if I'm loud enough, that's fine. Okay, perfect. Can anyone hear me okay? Yep. It's about the same, right?
Can you turn on the mic?
It is on.
It is on? Everyone hear me? Okay. I want to, just as David said, I want you to keep in mind that, of course, we're representing the Canadian and the US perspective. And when it comes to the internet and social media, there are no borders, right? So a lot of the case law sort of flows across. In fact, a prominent case here in Ontario is often cited in New York.
Excuse me. I'm afraid it's muted.
Is it? It doesn't work on this. Is that better?
It's on the top.
Oh. There, is that good? Yeah. Ah, hello. Okay. So, really, we, as David said, we want to keep it really open-ended and make sure that there's lots of time for questions. We're going to be talking about some of the developments in Canada and the US. And this is our context. And that picture is old, right? And Friendster no longer exists as a social media site. But regardless, we see all the flavor of the social media out there. And with our 800 million active users, we have about 17 million Canadians on Facebook. A lot more Americans, obviously, just thinking about the population. And these are what Facebook calls monthly active users. So they log on at least once a month. And the numbers have died down a little bit since last year. We're not seeing the exponential increase anymore because we're about 50% of our population now being on Facebook, and that's generally for every country when it starts to taper a little bit. Okay? But this is key. Default privacy settings. The devil is in the defaults, right? And only 15 to 20% of users change them. Has resulted in a lot of concern, of course, by the privacy commissioners, the regulators in Canada. And I want to give you a little bit of background here, not turning this into a legal seminar by any means, but just to understand the context with respect to privacy. And I know there are going to be other questions in the room with respect to legal issues for social media, like advertising rules, etc., which we are happy to discuss as when we get to the question-answer period. As David mentioned, we're going to focus right now on privacy. And the laws in Canada refer to the information flow through an organization. Collection, use, disclosure. And there are rules around collection, around use and around disclosure. In Canada, a very different framework than the US, we have a mix of federal and provincial legislation. The federal law, many of you would have heard of PIPEDA, or the PIPED Act, PIPEDA, you can call it any of those. No one ever uses the full name anymore. The Personal Information Protection and Electronic Documents Act. And the EDA part essentially makes an electronic signature as valid as a written signature. So you could have an electronic will. An electronic signature is as valid as a written signature under this law, which came into force in 2001. For federally regulated businesses, and now for any, as of 2004, any business that does not have, is not governed by their own provincial law. So in Ontario, there isn't a privacy law that applies to the private sector, so PIPEDA applies here. BC, Alberta, a little bit different. They have their own, what are called PIPA, Personal Information Protection Acts, that apply in those provinces, and Quebec has their own law. And then we have a little hodgepodge of health privacy laws specific to the health sector. So you can see it's quite a mix of different laws, and in some cases for a business, more than one law is applying to them, particularly if they're operating across Canada, right? So how do you deal with the fact that in the social media world, really, we don't care about the borders, right? It's really about where the user is. That's what it comes down to. It's not about where the data is, where the servers are. It's about where the user is. And that's quite clear from the case law. Okay, so that's really what if you have a user in Vancouver, they are going to be governed by the BC PIPA. Okay, and they have a claim under that law. So that's why, of course, the privacy laws are important to Facebook because they are targeting Canadian users. So many of you will know about some of the activity. The Office of the Privacy Commissioner of Canada investigated Facebook in 2009, very concerned about primarily transparency, right? Not being clear about what you're doing with your users' information. Some of the key findings of that decision in August of 2009 were too much sharing of personal information with hundreds of thousands of developers around the world, many of whom are not governed by any privacy laws at all, without users' knowledge, right? So these are those often quizzes, games, right? How much information is shared with them and why don't people know about it? That's changed a little bit now, right? There is notice. They've really worked on changing their privacy policy, and the commissioner was quite proud of initiating some of that change. Distinction between account deactivation and deletion was another big concern of hers, which is people thinking that when they're deactivating their account, their information is gone, and it's not. And so they've really tried to clarify the difference. A few extra steps if you want to actually delete your account, as opposed to just deactivate it temporarily. But there is the ability to purge your information, not that, you know, the other social media sites have picked it up, and of course the search engines, etc. But Facebook in particular will not keep your information in their databases if you delete as opposed to deactivate. So that the lack of clarity around that was a concern. And then just the general lack of transparency in Facebook's privacy policy, the fact that it was long, hard to read, no one read it, and not clear how the like feature worked, what exactly is shared with friends, what people should be alerted to in terms of what defaults to everyone, etc. So lots of concerns. In September, and she gave them a year, in September of 2010, she stated that for the most part, she was satisfied with a lot of the changes that Facebook had made to its privacy policy and to its practices. Still under investigation was the like button. You know, you like a site, what information is shared with the entity being liked, right, including IP address, and that she felt there wasn't enough transparency there. And this is her statement. Facebook is one of several rapidly growing and evolving internet giants that are presenting ongoing challenges to privacy regulators around the globe. So basically, not end of story. She will continue upon getting complaints to investigate. Okay, so I just want to a little bit focus on some of the court cases. I'm not going to get into them because then David won't have a chance to open his mouth. So, I am just going to give you sort of general trends. And we have so many cases. There was another one just last week. But we have so many cases where the courts still clearly are really struggling, not really understanding the whole social media sphere. There's a lot of blurring of the divide between public and private. And you have your typical, for instance, personal injury suits. I think we have now over 200 personal injury related suits that have gone through the court systems. This is your typical, someone wants long-term disability or claims loss of enjoyment of life, right? So they're suing someone who they were in a car accident with, or they have a huge insurance claim, and their Facebook page shows them ziplining or on a beach in the Bahamas, right? So your typical, there's so many of those types of cases. And the courts, the statement that's often used, and I mentioned it's a case that often is cited in the US as well, is to allow a plaintiff to hide behind self-set privacy settings risks a potentially unfair trial. So basically, we don't care what you set your privacy settings at. We're going to look behind the scenes once it gets to court. Okay? So, of course, users need to know that if they're fine with everyone knowing about it, then it's fine to share. But the whole issue, setting up your privacy settings to only friends, etc., the courts are really sort of ignoring that because they have no distinction between public and private right now. Okay? So, the more friends you have, basically, the less the expectation of privacy. So, oh, wow, you have 1,000 friends? Well, then obviously the whole world should know about it, right? is the kind of reasoning we're seeing. Stretching the law to fit the social media context. Really, the laws are not designed to deal with social media. Very much of a focus on fairness. And of course, looking at international cases, they recognize the fact that very similar issues are coming up all over the world, and it doesn't matter what jurisdiction you're in, right? Do you want to go to the US and then we'll come back to the coming up trends? Yeah, should we do it that way? Okay, excellent. Thank you, everyone. We're going to do a little bit on the US. I'll be back, and then we'll open up the floor again.
Want to switch through here? Okay, thank you. Everybody hear me okay? Okay, so as Fazila pointed out, unlike Canada, unlike the European Union, the United States does not have a comprehensive privacy framework in place. We do not have one unifying law that says, these are your privacy rights, these are how we're going to protect them, and this is what happens when something goes wrong. We do have a patchwork of various laws, HIPAA, which is related to healthcare. I'm sure many of you are familiar with that. There's a number of other laws. There are a number of state laws that govern what's known as breach notification, right? There's no yet federal law on breach notification, but there's one stalled in Congress. So we have a very different operating environment in the United States. Similar to Canada, we also have an organization, the Federal Trade Commission, whose job is to protect consumers. And they've been very active over the last year. Social media has given them some fresh fodder to investigate companies and to come out and actually start putting some safeguards in place, giving companies guidance about what it's okay to do with consumer information and what it's not okay. One of the, I think, issues for marketing folks is the fact that a lot of what you do and what my clients do who are marketing using social media is providing free content, right? Everybody thinks that everything on the internet should be free. The implicit bargain here is that it's not free. It's actually coming at a cost. From a marketing perspective, it's this online behavioral advertising, right? Getting a sense of who our consumers are, where they're going, what they like, what they don't like. How can we target our message to them in a way that's relevant to them and isn't just more marketing blather that they're going to tune out, excuse me. So the problem is, how do we balance the needs of the marketers to really craft a refined marketing message with the needs of consumers to have control over what they share with people? And I think, Facebook is exhibit A in this battle between what marketers and brands need and what consumers need. There's also been some recent activity just on the industry side in terms of coming up with do not track policies, coming up with their own sort of guidelines to help protect consumer privacy. Clicker here. All right, so very quickly, I just want to talk about a couple key FTC actions that are starting to frame the privacy debate in the United States. A Twitter case was started in 2010, was finally finished in 2011. It was the first social media case involving the FTC. And what the FTC had identified was that there wasn't enough control in the Twitter API, in the Twitter system, to prevent hackers from going in, accessing accounts, posting tweets as fake or anonymous users, and a number of other privacy concerns. The result was that the FTC came down with a 20-year ban on misleading consumers. And this sort of begs the question, was it okay to mislead consumers before that? And will it be okay to mislead consumers 20 years from now? Okay. The other issue for Twitter was that they had to agree to a compliance program. They had to put an information security program into place, and they had to agree to be audited periodically on how they were implementing that privacy plan. So it didn't take long for the FTC to notice that Facebook was running rampant with people's privacy. This is a 2011 case, and the crux of the issue was that Facebook deceived users about the public availability of private information. And I don't know if any of you have ever looked at a privacy policy. God knows I've crafted probably hundreds of them. But they all include a sentence that says, we can update this privacy policy at any time without notice. Okay? Which, for the moment, legally will fly. My sense is, based on some other cases I've seen, that may not be the case in the relatively near future. This ability to unilaterally change something as significant as a privacy policy without getting some sort of notice and consent from the people who are being affected. Ultimately, that was what was at issue with Facebook. Facebook was changing their privacy policy in a way that was altering users' privacy settings. And it was changing the way that users were sharing their information with developers, with other people on Facebook, and with Facebook itself without the user's knowledge. And I think that was the key concern for the FTC, is that people didn't know that these changes in the policy were having a technological sort of follow-on effect insofar as how it changed those relationships. The Facebook settlement involves some more significant but similar sanctions to what was issued to Twitter. A bar on misrepresenting privacy and security. Again, this is a 20-year ban. Does that mean it's okay to start misrepresenting privacy and security after the ban is up? I don't know. Hopefully we'll have some more privacy legislation in place or some better case law around it. Affirmative consent required for privacy overrides. What this means is that if you're installing an application in your Facebook profile, or you're somehow enabling a third-party connection, the user has to affirmatively consent to any way that is going to change their default privacy settings or the current privacy settings that they have. Another feature, and Fazila, I think, mentioned something similar with the Canadian Facebook issue, was this 30-day access limit for deleted accounts. After 30 days, if an account's been deleted, it's been deleted. Okay, you can't. A third party can't go back in and get stuff out of that account. It's not deactivated. It's deleted. It's done and gone. Like Twitter, Facebook has to create and maintain a comprehensive privacy policy and a technological privacy implementation plan. And lastly, Facebook has to submit themselves to third-party audits every 2 years for the next 20 years on compliance. So somebody's actually going to be taking a look at Facebook and making sure that they're living up to their end of the bargain. Getting back to legislation for a moment, a couple of the laws that we have in the U.S., and I sort of stole my own thunder here because I mentioned them already. There's the data breach notification laws are sort of a backhanded way to protect consumer privacy after the fact, right? So all the states have pretty much enacted laws that require a business to notify you if there's been a security breach and if your personal information has been compromised. Personal information is pretty broadly defined, and it's defined by different people in different contexts, but it includes things like your name, your address, your email address, your phone number. It doesn't even have to be as sensitive as social security number or something like that. What's interesting is, in the last year, California updated their state data breach notification law to require that third parties provide to customers their data breach notification policy upon request. And what I'm seeing in my practice is that we are now going back to terms of use and privacy policies and including language in these documents that say, if you're a California resident, you have the right to request our data breach notification policy. Okay, yes, it's only a California law, but because of the way social media ignores borders, it's very likely that A, other states are going to follow suit, but B, that you're going to have users who are in California. Okay, so we had this great idea, Fazila and I, before we started this, that we would tweet out to everybody in the social media universe to ask us your relevant privacy questions, and we didn't get really any responses. So what we're going to do is we're going to move this to the end of this discussion and figure that after we've talked to you guys for a while, you might actually have some questions that you want to ask. So I'm going to hand the mic back over to Fazila to talk about some recent developments and the trends in Canada, and then I'll step back up and talk about what I see going on in the United States.
And then if we have a quiet room, I will be talking. Okay. So I think it's great to do it this way because some of the things that David mentioned are coming up in Canada as well in terms of behavioral advertising, for instance, is one thing that's very new here. We have some new guidelines. If you look at that second bullet there, December 6th, the Office of the Privacy Commissioner of Canada issued behavioral advertising guidelines, and they're all focused on consent, right? Because under the privacy laws in Canada, that is a key principle. You need to get consent. And of course, there's so much discussion about that may not always be practical, right? And so in her guidelines, she speaks about getting opt-out consent, but that there are ways to do it, and she actually offers some guidance in that document. And I'm going to give you the website address. I should have put it on there. It's www.priv.gc.ca. That's our federal regulator's website address. Great resource tools, and you will find the guidelines. priv.gc.ca. Okay, priv.gc.ca, and then you can take a look at those guidelines. You'll find it on the sidebar because it's a pretty new release for her office. But really, it's about, in that context of targeted marketing, based on a user's activities, where they're going on the internet, their expression of interest, what can you and what do you need to do from a consent perspective? Okay. The first bullet there, just to backtrack for a second, this class action suit is ongoing. It started out of Manitoba, out of Winnipeg, and it's going to be the largest class action suit in Canada. It's already been certified by the Merchant Law Group, and very similar to the concerns in the US is the fact that it's in a time frame where Facebook was sharing a lot of information, without user knowledge about profiles and pictures with advertisers, and again, with third-party application developers. So we'll see where that goes in terms of, I assume it's going to get settled, right? And we don't, we'll get a sense of what that settlement amount will be. But that started in 2010, and it's still ongoing. There's still, in fact, the opportunity for people to enter that class action suit. So it's growing in number as well. So in terms of some of the new developments, one thing to really keep your eyes out for is Canada's new anti-spam law. Okay, it's called the Fighting Internet and Wireless Spam Act, FISA, and it's a little different than, for those of you who are familiar with the US model, it's CAN-SPAM there, which is very much, and correct me if I'm wrong, it's about email, right? It applies just to email communications. Commercial email. In the Canadian model, which is not yet in force, okay, the regulations were just finalized in the fall, and now we've had a little bit of a slowdown. I've assisted a number of organizations getting ready for this law, and then we had a change of government, and it hasn't been as high priority, but it's just a matter of time before, because the law is set, it's received its third reading, it's gone through all the steps through the legislature, it's just a matter of getting it into force now. And what is really interesting about it is it's not just about email. It's any commercial electronic message, okay, what's called a CEM. And that could be directed like texts, messages sent to social media sites, okay, targeted messages, email of course, but any sort of commercial electronic message will be covered by the new anti-spam rules in Canada. And it's also very different from the US because it's an opt-in model, which is about getting consent unless you have an existing business relationship, in which case you can imply consent. But otherwise you need to get express consent before sending a commercial electronic message. This is going to be quite costly for businesses to implement. From a marketing perspective, when you think about marketing lists, how do they get there? There's rules along what's an existing business relationship. Well, they need to have transacted with you within the last 2 years. Okay, so if they bought a product from you within the last 2 years, 2 years later, that existing business relationship has ended. So you can no longer send a commercial electronic message to them until you've got their consent. So there's all these rules, very, very challenging, and I've helped a number of the banks in the financial services industry. It is just figuring out what CEMs they send out was a task in itself, right? So this is a really large development. A lot of organizations are getting ready for it. I strongly suggest you look into FISA compliance. In the social media context, for the purposes of the conference here today, I wanted to mention to you that there's some definitions that are really, in terms of family and personal relationship. That is, you don't need to get consent before sending a CEM to a family member, okay? And there's a definition for who's a family member, and there's a definition for having a personal relationship. And personal relationship is a strange one because you need to have at least one in-person contact. In person, right? So this is, of course, the government of Canada not understanding the online world. So at least one in-person contact, and that exempts you from the consent requirement. So if there isn't, such as in the social media context, right, where you have fans and friends, then there's no personal relationship according to the law, and therefore you need to get consent, or they need to have somehow agreed to receiving that CEM from you. Okay, so I won't get into the guts of the law, but just keep in mind that FISA is something that you really need to think about from a marketing angle.
So what's compliance?
Sorry? Well, it came into, it received a third reading and became law in December of 2010. The regulations were finalized last year. A comment was due by end of September, and we now have those final regs. And they give us things like the definition for family and personal relationship. So a lot of it's all been fleshed out, but we don't have an in-force date yet. And we also don't know how much time is going to be given for businesses to comply. Because they may give, in 6 months. However, I'll tell you what Industry Canada's advice is prepare now, because that time period will be very short. Yeah. Yes?
This sounds about as cumbersome as the Do Not Call Act. Is it about the same level of complexity?
In fact, the goal is eventually to get rid of that list in Canada, to get rid of the Do Not Call and to bring it under FISA. Okay, so that it's all one. Because a CEM actually refers to voice as well.
because people snicker when you mention the do not call list.
Oh, I know. I mean, and the fact that it was sold, right? At one point. Yeah, the CRTC sold that. Yeah, so there was a huge privacy issue with that. But the do not call list isn't really working too well. What the government wants to do, and the provisions are there for it in FISA, because a CEM is also defined as a voice message, right? So, but they've carved it out for now, so the do not call list will continue to operate, and eventually it will disappear and come under FISA as well. But yes, I agree with you. It's almost as bad. Yeah. One other FISA-related question? Yeah.
What do you think the likelihood of this being implemented? Sorry. What do you think the likelihood of this being implemented? That companies will just throw up their hands and give up something like email marketing, which is, proven to be pretty effective in some cases.
Oh yeah, absolutely.
Like, do you think it'll happen a lot? Like,
I think the issue with FISA is that the fines are really heavy. So the fear factor of being like they're creating a spam reporting center. Industry Canada is for people to have an avenue to report spam. Entire investigations unit. So they're really prepping for this law. Will businesses say, we'll continue to operate and something goes wrong? I don't think so. I think a lot of businesses are looking at figuring out at least what lists are consent-based and where they need to think about consent going forward. Particularly, the reason to prep for it is so that you can potentially get that consent, even if it's opt-out consent, but that you get some form of consent prior to it coming into effect. And the fines are really heavy. They emulate the Competition Act, so I think businesses are taking it quite seriously. Couple of
You want to finish first, or?
yeah, I don't know. I guess if they're FISA related, are they?
What about paper, like flyers and stuff like that?
Doesn't affect that. No, this is about commercial electronic messages, so not about direct mail.
So I guess we're opening up to questions at this point.
I think we're going to turn back first, right, to David.
All right.
So let's do that, and then of course, if they're FISA related or generally about social media on the Canadian side, I can take those. But let's transfer back to David for some of the trends in the U.S.
Thanks, Fazila.
Yeah.
I'll try and keep my comments pretty brief.
Trying to give a good jumping off point here. How many of you read the Wall Street Journal and follow the What They Know series? Really? Okay, well, the Wall Street Journal wrote a series of articles about how people's activity online is being tracked through the use of persistent cookies and other identifiers that are being plopped onto computers as people visit websites. And so I think a lot of this brought it into the public consciousness. And last year we saw two bills start to gain momentum. One is the Do Not Track bill from Senator Rockefeller, which goes to allow people to stop this online tracking. And then the other bill is sort of this more generic privacy bill of rights, okay? They were all the rage about 6-8 months ago. I haven't really seen anything come up about them lately. I think largely because of all the noise around SOPA and PIPA, these other privacy bills have sort of lost their momentum. But we do have federal legislation that is at least being discussed and is being looked at, and federal right to privacy is now really being discussed in the U.S. As I mentioned earlier, there's also the Federal Trade Commission. And the Federal Trade Commission has been very, very active in protecting consumers and protecting privacy. And not just privacy, but protecting consumers broadly in their online activities. And one of the more often talked about pieces of communication from the FTC are their blogger guidelines. And somebody asked me last night at dinner, well, I'm in Canada, would the FTC blogger guidelines apply to me? And my answer is, if you are targeting people in the United States, if you're writing about a US-based product or you're writing to US-based consumers, then absolutely, the FTC blogger guidelines apply to you. And we could probably spend a whole hour on the type of disclosures that are necessary to comply with the FTC blogger guidelines. I'm not aware of any action right now where somebody has run afoul of them, but I think for all of us who are in social media, it's very, very important to be aware that we have disclosure obligations when we're talking about brands, when we're talking about our own company, when we're reviewing third-party products, whatever it is, there are disclosures that need to be made. And I sense that these will start to become more prevalent in the coming year or two. I really think that 2012 is going to be the year that the legislators and the courts kind of wake up to what's going on in social media. Just in my own backyard, I tell you, this is how I know that social media is really a mainstream issue. When I was on the flight up here from Chicago, the American Way magazine had a story about the guy from the Chicago car dealership who got fired for posting on Facebook about the lousy food at his company's event. And it's one of the early cases from 2011 where the National Labor Relations Board stepped in because an employer had fired an employee for what's known as a protected activity. And I can't go into all the details of how the National Labor Act applies or what the NLRB's total role is, but basically this guy posted something on his personal Facebook page that was not nice is not the right word, is unflattering about his employer. And his employer asked him to take it down. He said it's none of your business, and they fired him. NLRB sued the employer saying you can't do that. That's his constitutionally guaranteed right of free speech, even if it's about, especially if it's about conditions in the workplace. So we'll see a lot of that. That was one of the early cases in 2011. Since then, there have been a host of other cases that have come online. A case that I'm watching particularly closely is a case involving a company called PhoneDog. And in that case, an employee was paid to tweet about PhoneDog or their products or something. He was being paid to get on Twitter and promote his company. He left, and I don't know the circumstances of his leaving, whether he was fired or whether he chose to leave, but he took his Twitter followers with him, and his employer sued him, claiming that they owned those Twitter followers. Now, I don't know how this case is going to come down. My fear as a lawyer is that because of the cost of litigating a case like this, and because of the fact that the defendant is just, a guy and not a company with deep pockets, it's probably going to settle before we get any sort of a judicial determination of who owns these Twitter followers. And this is a question that I get asked all the time. Who owns my Twitter followers? Who owns my LinkedIn connections? And to be honest, the law's not clear. And that's really the best answer I can give you. I would say every case is facts and circumstances dependent, but that's where we'll leave it for now. And then lastly, as I mentioned earlier, there are industry initiatives starting to come online. People are talking about, what type of information do we need to disclose? How do we disclose how we collect information, share information? Really quickly, just to give you guys a summary of kind of where I think Fazila and I are coming from. Privacy rights are going to continue to evolve both in the US and Canada, at least in the US, and it sounds like Canada as well. Both users and businesses that use social media are going to be subject to new federal and possibly state regulation. From a social media advertiser standpoint, as brand ambassadors, as people who do the marketing for other people, some things that you need to be aware of. Develop a social media policy, okay? I can't tell you how many people I have talked to who think, we'll get around to it when we need to. Most of the NLRB cases are popping up and going forward because there is no social media policy in place that defines an employee's role within the company and how they are allowed and not allowed to use social media. I mean, that alone is going to save you the cost of a labor lawyer, okay? In addition, there's other things that need to be in that about privacy, about use and collection of data. Review and update your company's privacy policy. Again, there's state laws coming online. There's the data breach notification laws. There's other things. A lot of these privacy policies were written a decade ago when people were first doing, e-commerce. Like, okay, I've got a retail site. When somebody buys something in a shopping cart, I'm collecting some information. A lot of these privacy policies have not been revisited since then. And now you have social media. You have people coming in through Facebook. You have people coming in through Twitter. You have the APIs opening all this information up. None of it is addressed in the majority of the privacy policies that I see. conduct due diligence on your marketing partners. Understand how they are gathering information, how they are storing that information, and how they are sharing that information. Because those three areas are all legal risks. So with that said, Fazila and I would like to open up the floor to, okay, well, we've got an online question, so we'll start out with that. Great.
Fantastic. So this question, I'm going to try and read it off my laptop. With Visa, it's a question on Visa. What if a Canadian sets up a branch overseas with no Visa-like regulations? Let me try to get to the end of this question. Yes. So can they, without any Visa, can they still spam?
Not to a Canadian.
So the answer is not to a Canadian.
Yeah,
I'll
that's
post that
the-
response to the person
yeah.
asking that question. So even if you're outside, so they would be
Yeah.
subject to the Canadian
They're
law.
subject to the Canadian laws if they're going to target a Canadian. Exactly. So a Canadian will have a cause of action here. The issue is, will they be able to recover, right? Because then they need to be able to, the regulators here would have to enforce a judgment against an overseas spammer. And so it's an enforcement issue, but it still would be a finding of non-compliance.
Perfect. Thank you. Post back to me.
Just a clarification on the phone dog instance. It should be noted that that guy was using, he was tagged as being part of that company. So it's not like we're not back to the situation where he was doing it on company time with company owned, property, equipment. It was, he was tagged, like at the end of it, K-Mullet, and then from this company. And so the assertion was that, well, if you're representing the company and you're paid to do so, so just so everybody knows, that wasn't just an individual that's tweeting occasionally about their company and so forth like that. Question, are you familiar with the Red Bull case where the gentleman was fired for saying something derogatorily about...
Is this Canada or the U.S.?
No, I'm sorry, this is U.S.
Okay.
About the company that he worked for. He was part of the distributorship there. And that one, I too believe, also got settled out of court. Are you familiar with that one?
I'm not familiar specifically with the Red Bull case, but there have been a number of cases, mostly late last year, that have involved, firings related to Facebook postings, and in almost all those settlements, the NLRB found for the employee. I don't know the facts and circumstances, but the NLRB also came out with very comprehensive guidelines about social media and what employers should know about how employees use social media, whether it's within the context of their employment or outside the context of their employment. And if I could back up real quickly just to address the comment on the phone dog issue, I did mention that he was employed by them to tweet for them. I think the bigger issue is, what if you're an independent contractor? What if you're a social media marketing agency and you've been hired by a brand to tweet about their brand, and all of a sudden their followers go from a couple hundred to tens of thousands? Are those your followers? Are they the brand's followers? Until we get a little bit more guidance, I think it's not entirely clear, and I could make an argument going either way.
Isn't that work for hire?
Depends on what the contract
Okay,
says.
we're running out of time because we have another great session coming up. We're going to give Fazila one last comment, and then if you have questions, catch them at lunch. And
Okay.
so lunch is at 1 o'clock, by the way.
Just one comment I want to make, because I didn't really address the employment issue and the firings. In Canada, it is prevalent. People are getting fired for their postings, and they're being upheld as rightful terminations. So our largest group firing was in the context of the Stanley Cup riots last year in Vancouver, where people posted themselves looting, drinking, and just going wrong night. Employers didn't want to be associated with those employees. There was a mass amount of firings that ended up in court and were found to be rightful terminations. So just keep in mind that in Canada, we're seeing a lot of that.
And I guess that would also be the BlackBerry executives.
Yes.
So we're going to switch over. Our next panel coming up is Facebook advertising for ROI results. So we'll do the transition to the camera calls for
My first web development. And I